5 seconds to go. Start. In support of his submissions, he also referred to the decisions of this court in Union of India versus Prafulla Kumar and another. The counsel for the respondent, Shri Abhinav Mukherjee AOR, has contended that the trial court was right in dismissing the discharge application. He submitted that the courts could not have conducted a roving inquiry while adjudicating an application under Section 239 of the CRPC. The short question arising for consideration is whether the appellant is entitled to be discharged of the proceedings initiated against him under the PC Act. Section 227 of the CRPC relating to discharge is as under. If upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and the prosecution in this behalf, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for so doing. The threshold of scrutiny required to adjudicate an application under Section 227 of the CRPC is to consider the broad probabilities of the case and the total effect of the material on record, including examination of any infirmities appearing in the case. In Prafulla Kumar Supra, it was noted that, thus, on a consideration of the authorities mentioned above, the following principles emerge: that the judge, while considering the question of framing the charges under Section 227 of the Code, has the undoubted power to sift and weigh the evidence for the limited purpose of finding out whether or not a prima facie case against the accused has been made out. Where the materials placed before the court disclose grave suspicion against the accused which has not been properly explained, the court will be fully justified in framing a charge and proceeding with the trial. The test to determine a prima facie case would naturally depend upon the facts of each case, and it is difficult to lay down a rule of universal application. By and large, however, if two views are equally possible and the judge is satisfied that the evidence produced before him, while giving rise to some suspicion but not grave suspicion against the accused, he will be fully within his right to discharge the accused. That in exercising his jurisdiction under Section 227 of the Code, the judge, which under the present case is a senior and experienced court, cannot act merely as a post office or a mouthpiece of the prosecution, but has to consider the broad probabilities of the case, the total effect of the evidence and the documents produced before the court, any basic infirmities appearing in the case, and so on. This, however, does not mean that the judge should make a roving inquiry into the pros and cons of the matter and weigh the evidence as if he was conducting a trial. In Sajjan Kumar versus Central Bureau of Investigation, the court cautioned against accepting every document produced by the prosecution on face value and noted that it was important to sift the evidence produced before the court. Stop.